I'm going to call now Jason Kafoury, organizer for Honest Election Oregon, Patrick Llewellyn, director of State Campaign Finance Campaign Legal Center, who is going to be remote, I believe.
Yeah, he's in D.C.
Good morning, Jason.
Morning.
You can go ahead and start your testimony, presentation.
I hope everybody had an opportunity to read the Sunday editorial in the Oregonian, a complete betrayal on campaign finance reform. Dear Senators, I dedicate, my name is Jason Kafoury. I'm an organizer with Honest Elections Oregon. I dedicate my free time in life to this one political issue, trying to limit the domination of big money in politics, because I think it is the most important issue that defines all of the problems across legislative conditions that we have day to day. Here in Oregon, we are one of 5 states with no limits at all on political contributions. And I want to give you a little bit of the backstory of how we got here today from where we were 2 years ago when we passed 4024. When you work on housing policy in this building, you know who's at the table? Experts on housing policy. When you work on land use, you work with land use experts. When you work on environmental issues, you work with experts on environmental policy. Why in the world would the legislature draft up a bill that changes 40% of what we agreed to in 2024? 40% has been altered or changed with zero input from good government groups. You'll hear from the Campaign Legal Center, Patrick Llewellyn, here in a couple minutes. This national organization works in all 50 states, and they're experts on exactly what the U.S. Supreme Court has passed, what federal judges have passed. They know even Oregon case law, and they can apply the incredibly complex world of campaign finance reform with what the law is going to allow and what challenges may happen if we don't get this right. This is one of those few issues, campaign finance reform, where Democrats, Republicans, and independents overwhelmingly support this issue. When we look at the voters, in Multnomah County and in the city of Portland, we had campaign finance reform passed in 2016 and 18 with 89 and 87.4%. When was the last time you saw a yes vote on anything with 89% yes? Here in the state of Oregon, almost 75% of the people amended our Constitution in 2020 to say, yes, we do want to have contribution limits and we do want to have transparency. In 2024, a group of Good Government Coalition advocates put together a ballot measure. We were tired of the legislature not actually implementing real campaign finance reform. We went and collected 100,000 signatures. We were on the way to the ballot. And guess what happened? The legislature did a historic thing. Speaker Fahey, Scott Moore at her office, brought together business groups, brought together labor, brought together both the spenders, the people that worked, the boots on the ground folks, and they brought the campaign finance reform advocates. And you know what we did in a matter of weeks? We passed, the first time in 150 years, a historic achievement for the state of Oregon. Real contribution limits and real transparency. Now, those limits are supposed to go into place next year, 2027. The transparency is supposed to start in 2028. We still have 2 more years to get the transparency right. So, what happened since 2024? There were work groups put together. I worked tirelessly with Speaker Fahey's office, with Scott Moore. We had an agreement for a year and a half, and it was a very simple agreement. We're not going to change the policy of 2024 unless we have group buy-in with everybody on board. That was the deal. We can talk about technical fixes, and we spent a year and a half working through trying to get to technical fixes. Then what happened? For the last 8 months since the end of the last session, complete radio silence. I haven't had one phone call or conversation with Scott Moore or Fahey's office. But you know who I was talking with? The Secretary of State's office. I've talked to Tobias Reed twice in the last couple of months. I've talked with Rico and his staff 4 or 5 times. And Do you know what was happening behind the scenes that I learned about 2 weeks ago at 5:23 p.m.? A massive rewrite, 40% all new stuff was put into a bill that I had worked really hard 2 years ago with all of you to pass. And what does that say? Do you know who was at that table that was working to write that up? The big spenders were there. Our Oregon folks, the labor unions, the business community, they all were in the room drafting up these edits to 4018. Now, there are massive policy changes in this, and this is not something that we should rush through in this short session. Do you know how much public debate has happened so far on this topic? There was an 83-page document posted at 5:23 p.m. 2 Tuesdays ago for an 8 a.m. hearing. We had one person, Dan Meek, who was able to make that, to actually provide testimony. 2 days later, they had another hearing where they only took 3 people that were opposed that were sitting here. I was prepared to testify remotely. They didn't take any remote testimony. That's been the extent of the entire debate that we've had on this topic in the legislature. Well, let's talk about some of the big substantive policies that this does. And Patrick Llewellyn will touch on this. It says that if you create multiple entities, and as long as it's not the, quote, sole purpose of the entities, you can effectively eliminate all the contribution limits by giving unlimited money and evading the contribution limits. There's no reason to have that phrase sole purpose in there, 0, unless you were writing it to avoid the contribution limits and the disclosures. 2, they took out the definition of coordinated expenditure from the definition of contribution. Again, small word changes. What does that actually do in real life? So I'm Chevron. Before, under 4024, I'm banned from directly coordinating with a campaign. I can't say, here, would you like $1 million ad? And what if I change it to say this to attack your opponent? What if I do this? That was all banned. Now they've taken out that definition of coordinated expenditure. I don't think it's banned anymore. I think we have created, if this passes, we have created a third type of massive money. Independent expenditure, direct contribution to a candidate, and suddenly unlimited coordinated expenditures with candidates. That's scary. That's really scary.
Mr. Kafoury?
Yeah.
Just let you know that you have about less than 3 minutes left.
Less than 3 minutes. Okay. I want Patrick Llewellyn to be able to say a couple words. I will just say, folks, let's slow this down. Let's get it right. Let's get the good government folks back at the table. Senator Manning, as you pointed out, there's a lot of stuff in this. You're not going to have time to really get through all of it. If the Secretary of State would like a little extra time to get this right on the transparency disclosures, I'm happy to have that conversation. We can change 28 to 29 or something like that in terms of implementation. That's fine. But going and doing a huge gut and stuff against the wall, the media is watching, the citizens are watching. This will be, and I will just leave you with this. I ran into one of your colleagues who's a multi-decade senator, and what they told me was this process that you guys are doing right now at the legislature on campaign finance reform is appalling. It's a big word. It really is appalling. To have a gut and stuff with only big spenders at the table and no campaign finance reform advocates is not the way our democracy should work. And I really hope we can get this right and not do this big, huge gut and stuff bill. I'd like to leave some time for Patrick Llewellyn. And I will just say that, we're going to have to go back to the ballot if we can't work together collaboratively to keep this campaign finance reform. But this time we'd have to do it as a constitutional amendment and not as a statutory.
Thank you. Jason, you want to stay?
Oh, sure, I'll stay.
Few
Yeah, let him
questions?
testify.
Let's wait until we get it from the Patrick. Patrick, go ahead, please.
Thank you very much, Chair Jama and members of the committee. Thank you for the opportunity to speak with you this morning. My name is Patrick Llewellyn, and I'm the Director of State Campaign Finance at Campaign Legal Center. CLC is a nonpartisan legal organization dedicated to solving the wide range of challenges facing American democracy. Now, 2 years ago, the Oregon legislature accomplished a historic achievement in enacting 4024, groundbreaking legislation enacting contribution limits and meaningful transparency requirements. And while it's commendable for the legislature to see how those reforms can be clarified and strengthened, the current HB 4018 contains several provisions that do neither. As the letter CLC submitted to the committee last week outlined, HB 4018 would weaken laws intended to protect against corruption, fail to fix notable shortcomings of HB 4024, and add new ambiguity to the law. And I see time has been added. I'm happy to talk about a couple provisions that stand out to me, but want to be respectful of the committee's time. So two provisions that stand out to me in this regard. First, HB 4018 would remove the explicit coverage of coordinated expenditures within the definition of contribution. And as the Supreme Court has recognized for 50 years, coordinated expenditures with candidates are indistinguishable from giving cash to candidates. And any campaign finance system that fails to fully account for coordinated expenditures as a form of contributions will wholly fail to prevent evasion of those contribution limits, rendering them meaningless. HB 4018's deletion of this provision could raise serious questions as to how coordinated expenditures are or will be treated under Oregon law. And moreover, I am not aware of any other jurisdiction in the country that has amended the definition of contribution to remove explicit coverage of coordinated expenditures in favor of an implicit coverage of them under another part of the definition. Second, HB 4018 would severely weaken the anti-proliferation provisions of the law, which are intended to prevent evasion of contribution limits by the creation or use of multiple entities. Now, under HB 4018, multiple entities would only be treated as one entity sharing a contribution limit, even if they were established, financed, maintained, or controlled by the same person, if they were created for the, quote, sole purpose of evading the contribution limits, end quote, in the bill. That provision sets an extraordinarily high standard that, in my view, renders enforcement of the anti-proliferation provision exceptionally difficult. As our letter noted, a person could seemingly create multiple entities with a purpose of evading the law. So long as they have at least one other purpose, they would succeed in evading the law without repercussion. And I am not aware of any other jurisdiction that sets such a standard. Rather than build upon HB 4024's reforms to amplify the voices of everyday Oregonians in the financing of campaigns for elected office, some of these provisions would further entrench the power of wealthy special interests. In short, I am grateful to the committee for holding this informational hearing and urge the committee to consider alternatives to HB 4018 as it is currently drafted. I'd be happy to speak further to any of the issues raised in our letter or to answer questions from members of the committee. And thank you again for the opportunity to speak with you this morning.
Thank you, Senator Golden.
Thank you, Mr. Chair. Mr. Kafoury, you mentioned a little bit of the history of the last few years, including the ballot measure that you and other good government groups put together. I think you said you had gathered 100,000 petitions, and I think it was not unlike the measures that you successfully passed in Multnomah County and Portland. And you agreed as a group to drop that initiative petition in when 4024 was being crafted. What was your understanding of that agreement that led you to drop IP9?
Our understanding at the time, working with Speaker Fahey and Scott Moore, was that if we dropped our ballot measure, which we had already spent $400,000 or $500,000 gathering those signatures, that in return for dropping that, 4024 would only have technical fixes that we would collaboratively have a working group towards that we established, and we did that for a year and a half. The problem has been whoever was working behind the scenes over the last 6 months to draft this current 4018 completely shut us out of the process. And you know, sometimes there's good rationales for why changes happen. The problem is right now, I don't know who wants these changes. I don't know who drafted the changes. I don't know if there's unintended consequences. I mean, literally, this has been dropped on us, and we've been having national experts, look at this stuff. We've been given a week and a half to look through this and try to come up with comments. This is not the way democracy should work. This is a complex thing that should be worked at a regular long session, not in a rapid short session fashion like this.
But
Follow up.
But it was explicit that were there to be further changes after 4024, if that were to be changed, that the good government groups would be informed and involved in those discussions?
Absolutely. Yeah. I would never have agreed, nor would all of our coalition have agreed to drop our 100,000 signatures unless we thought 4024 was going to actually move forward and become law.
And what are the major groups that comprise what we call the good government groups?
So we've got the League of Women Voters, there's Honest Elections, Portland Forward, Common Cause, COIN, Indivisible Network. There's a series of smaller groups, but those are the main five.
Thank you, Mr. Chair.
Thank you. Vice Chair Starr.
Thank you, Mr. Chair. I have a question for Mr. Llewellyn.
Thank you.
So we just heard testimony from the Secretary of State, his representatives, basically that says nowhere in the world, no state has a kind of campaign finance regulatory scheme that is contemplated in House Bill either 4024 from last or 2 years ago, or even the slightly modified version in 4018. In your experience, isn't there other states that Oregon could look to as a potential model so that we are not in a situation where we're doing a one-off, where our Secretary of State is having to try to find a vendor who actually could create all of the necessary technological whatever it would require in order to create this transparency for the public? Can you comment on that?
Chair Jama, members of the committee, Senator Starr, there certainly are aspects of the law that was passed in 2024 that are unique, but several aspects of 4024 are not unique. For example, as Mr. Kafoury mentioned, the vast majority of states at this point have contribution limits. And while the allowance of certain kinds of in-kind contributions from membership organizations and membership organization political committees is unique in my view. I'm not aware of other jurisdictions that have similar specific and large in-kind contribution allowances from membership organizations. The simple fact of contribution limits is not unique at all. Similarly, while I can't say that I am familiar with the anti-proliferation laws of all 50 states, having anti-proliferation requirements, that is requiring that contributions by entities that are established, financed, maintained, or controlled by the same person or group of persons is the rule. It is not the exception. That is common across most campaign finance systems, and it's precisely because without those types of laws, a person could so easily evade contribution limits by simply creating multiple entities that those limits would be meaningless. And while the transparency provisions passed in 4024 that require the disclosure of the original sources of money for large campaign spenders in Oregon it is among the first in the nation. It is not the first transparency law to require that. For example, Arizona voters passed the Voters' Right to Know Act a few years ago, which similarly requires large campaign spenders in the state to disclose the original sources of big money spent to influence elections there. So while there may not be, an identical campaign finance system elsewhere that Oregon could simply point to say we want the exact software platform for that state. I don't think that there is any campaign finance system at the state level that is identical from any one state to the other. There are always going to be at least some variations. And while there are unique aspects to the Oregon law that was passed 2 years ago, I would say the vast majority of it aligns with the contribution limit systems of other states, and the transparency provisions have analogs in at least a couple of other states.
Thank you. Any additional